We're talking about critical race theory. In particular, there is a lawyer, goes by the name of David Pivtorak, who is filing a lawsuit against the government of California over CRT, specifically saying that California, your hiring policies are discriminatory and they're unconstitutional, and we're going to do something about it. So we want to go through this. We spent some time yesterday talking about critical race theory. If you are not familiar with this concept, I'd invite you to go check out that show, or at least that segment. We should have that clipped up by now, but comes over from an article from a guy named James Lindsay at newdiscourses.com. Gives a very nice summation, 2-page summary of what critical race theory is. And it's important. You're hearing it all over the place. You're seeing this sort of pervade itself into all the different facets of our life, and including our government, including in California. And so I want to go through this. We're going to have to go through it relatively quickly, but I want to show you what it looks like and what some of these issues that we're arguing about. Let's get into it. So as we see here on Twitter, David Pivtorak says, we have filed our opposition to the California government's motion to dismiss our critical race theory class action. So what he's talking about, he is forming a class action, which is a large number of complainants, so people who have a common cause or common complaint, bringing them together, suing California. California now filed what's called a motion to dismiss. They said, no, you don't have any basis for bringing this lawsuit. What are you guys, nuts? So what he's talking about is the response to the motion to dismiss. So let's take a quick look at it. He says, when we tried to stop them from using racial preferences in hiring and promotions, they filed a motion to dismiss under California's onerous anti-SLAPP law as an intimidation tactic, using the threat of adverse attorney's fees. This is why we need your help. Please donate so that we can match the government's resources and win this litigation battle. Court documents are in the link. So if you want to go support this gentleman, check him out at Piv4Law, PIV4Law, over on Twitter. And if you go there, you'll see a direct link to the GoFundMe that he's referencing. I think we have a screenshot of it here shortly. So I want to take a quick look first. I think this is the motion to dismiss, the response to the motion to dismiss. So California says, you can't sue us over CRT stuff. This is nonsense. We want to dismiss. Here's what he says back. The sole purpose of this action is to affirm the principle enshrined in law that, quote, basing present discrimination on past discrimination is obviously not right. For decades, the state of California has embraced merit-based, colorblind policies with regard to its employment practices. These policies prevent government officials, no matter how well-intentioned, from attempting to manipulate the racial demographics of their workforces. Defendants who lead California's largest state agencies bemoaned these race-neutral policies and their own agencies as, quote, institutionally racist. Okay. Simultaneously, they accused white employees of benefiting from and perpetuating the, quote, systemic inequity that has led to their overrepresentation in the workforce. Defendants use this to justify their implementation of thinly veiled racial quota systems that seek to correct this imbalance. Hear that language? We talked a lot about this yesterday. White privilege and white this and white this, right? White employees, racial quotas, institutionally racist, systemic inequity. Okay, all right. Plaintiffs filed the instant action to enjoin defendants' race-conscious employment policies, which violate state and federal law. So the class action, the plaintiffs are suing to stop them from using these policies in their hiring decisions. Defendants' anti-SLAPP motion fails because its strained reading of the complaint misrepresents what plaintiffs allege as the basis for the government's liability. The complaint's first sentence states that this class action seeks to eliminate discriminatory policies and customs in California state agencies that institutionalize racial preferences. It is made clear repeatedly throughout the pleading. The basis of the lawsuit is not the defendant's speech, but their implementation of racially discriminatory employment policies. So what does all this mean? The SLAPP stuff in California, it's free speech stuff. We've talked about this, right? Basically, you have certain protections, and if somebody is suing you in the SLAPP context, I'm having a difficult memory blank remembering what we were talking about what context we were talking about that in. But it's essentially free speech, and if somebody is suing you, like filing a cease and desist or filing a lawsuit, in order to chill your speech, in order to stop you from talking, there are rules against that. You can't just do that. You can't just be a billionaire. Somebody makes a YouTube video, you sue them for saying something that they're lawfully entitled to say, and you want to just try to silence them. Well, there's rules against that. You can't do that. You can't sort of use the legal system as a sword to infringe upon somebody else's protected ability to speak. And here, the government is saying, well, that's exactly what they're trying to do here. They're trying to say that what we're doing is bad because it's just language. We're using things like institutionally racist and systemic inequity and blah, blah, blah. They're saying, the government is saying, they're attacking our free speech. They're attacking our ability to communicate these ideas to our workforce. And the class action is saying, no, we're not. We don't say whatever you want to say. We don't care about that. We care about the implementation of these policies. We care about people who might want to work for you, California government, and you say, no, we can't hire you because you're white, and we have these thinly veiled racial quota systems. That's the crux of the suit. It's nothing to do with the speech. The speech is problematic, sure, but it's about what the policies are that you have enacted in California. So it says here, even so, plaintiffs, so the class action lawsuit sufficiently establishes the likelihood of success on the merits. There is no question that defendants' attempts to socially engineer the racial composition of their workforce violates California and U.S. Constitution. During California's affirmative action period in the 1980s, plaintiff faced rejection while applying for employment at the Department of Game and Fish based purely on his race. Now, because of California's policies, he is once again faced with the prospect of this indignity in applying for a promotion he desires. This is precisely the type of situation the law is meant to address, and defendants' abuse of anti-SLAPP statute to cynically intimidate an employee with a looming threat of an adverse attorney fee award is not something the legislature ever intended when passing the law. So this guy files suit, they respond back and say, oh, you're suing us? How about this? How about we rely on this free speech stuff? We're allowed to say whatever we want because we're the government. And if you sue us and lose, we're going to ask for attorney's fees. We're going to come down. We're going to, with the weight of the federal government, or the state government here in California, and we're going to make you pay for all of this litigation that you have incurred. They're saying that's ridiculous, okay? You're not allowed to, just like the anti-SLAPP statutes prevent somebody from doing that to you as a sword, you can't use the statute itself as a basis for also using it as a sword, claiming that you can get attorney's fees. So this is the GoFundMe. You can see here, class action to stop discrimination in California government. So if you want to support them, go give that a shot. It says this class action seeks to eliminate discriminatory policies in California. Shortly after the national upheaval stemming from the death of George Floyd, the heads of California's largest state agencies started engaging in racially divisive messaging to their employees. White employees at these government agencies were told that they were guilty of bolstering systemic racism and, quote, white supremacy purely based on the color of their skin. These agency heads also accuse the employees, civil servants who have dedicated their entire lives to protecting California's resources, of, quote, perpetuating the violence of the system if they did not engage in their boss's preferred method of political activism. Talked about this all day yesterday, right? We went through that item by item, and the language there that is being promulgated by the critical race theorists is this idea that if you are not actively anti-racist, then you are necessarily racist. In other words, if you are not out there every day screaming from the rooftops, that's racist, you're a racist, this guy's a racist, that car's a racist, that sandwich was racist, that doorknob's racist, then you are also a racist by negative participation, by not claiming that you're anti-racist or by not actively participating in anti-racism, you are a racist. And so California government apparently is doing the same thing. Using the accusations as a backdrop, the agency heads announced the implementation of work policies that are rooted in critical race theory. Policies intend to institute racial quotas into hiring, promotion, and other aspects of employment in violation of the law. State government, represented by the California Department of Justice, is going to throw its nearly limitless resources to stop this lawsuit and allow these unlawful policies to move forward. So if you want to go and support them, you certainly can. I want to show you the original lawsuit. This looks like this was filed back on October 13th. And this is submitted, as we know, by David Pivtorak, right? California bar number, Pivtorak law firm out in California, filed October 13th, 2020. So this guy's been working on this for some period of time. You can see here, this is a complaint for declaratory and injunctive relief and damages. So what are they asking for? We have Guy or Eisen, individually on behalf of others as taxpayers, also suing the Director of California Department of Fish and Wildlife. And what else do we have? Okay, so declaratory. So the lawyer is asking the court for a declaration that the policies that are being used here are not lawful, unconstitutional. Also asking for an injunction, which is the fancy way of saying that we want you to tell somebody to do something. We want you to require that they take one particular course of action. In this case, very likely, we haven't gotten to it yet, but very likely stop using these policies, stop hiring and stop having conversations with employees and based around critical race theory. And then, of course, they want damages. So damages would mean money, anything that was lost. Anybody who was supposed to be promoted and was not, well, they suffered some damages. They suffered the difference in pay that they would have received in their new position. They don't have that, obviously. So there should be some compensation for that. So let's take a quick look at the lawsuit. We're going to go through this relatively quickly, like I mentioned, see if we can sort of tease out what's happening here. This is the preliminary statement, as we know, seeks to eliminate discriminatory policies. Defendants are Wade Crowfoot and Charlton Bonham. They are acting Secretary of California Natural Resources Agencies. They've implemented policies called critical race theory. So these are the people who are being sued. After the national upheaval, after George Floyd's death, they made these changes. The introduction, the essence of critical race theory is the promotion of racial homogeneity and resentment towards people of, or homogeneity, is that how you said? And resentment towards people of different races. In order to understand the discriminatory nature of California's conduct, it is crucial to understand what CRT is and how it manifests itself. Began in the 1970s as a study of law as it pertains to the issues of race. Its stated goal was revolutionary political change and repudiation of the idea that the Constitution and law would adequately address racial problems in society. We talked about this yesterday. The revolutionary approach, right? Everything is racist. You have to call everybody racist in order to create this division, in order to create some separation that will spark a revolution, that will spark some cataclysmic changes in this country. Because if the entire system is racist, if the entire system is systemically racist, well, you got to get a new system. You can't fix that, right? If the house is falling down, you can't prop it up with some duct tape. You got to knock it down and build a new one. That's what they're advocating for here. They're saying that we need dramatic change in this country. The only way to do that is by creating more division. Critical race theorists, we have Richard Delgado and Gene Stefancic in their seminal text called Race Theory describe it as such. We've already read through a lot of that yesterday. The overarching principle is that racism is not aberrational in society. It is the status quo. It means every human interaction, the question is not did racism occur, but how did racism occur? Talked about that yesterday. The term systemic racism often used interchangeably with white supremacy. They also talk about that any white benefit comes from oppression, which is dubbed as white privilege. All right, this is in a court document. We have, according to the CRT, all white Americans are racist, regardless of who they are and how they behave. They are complicit in upholding white supremacy. The term silence is violence originates from CRT. There is no neutrality, no just being a good human being. Any white person not engaging in CRT is declared to be complicit in perpetuating white supremacy. California proliferates these ideas by explicitly accusing class members, civil servants that have dedicated their lives to California, of, quote, perpetuating the violence of the system. Defendants also use the, quote, silence is violence canard against class members, indicating that unless class members buy into and engage in a specific type of political activism that the defendants support, that California supports, that class members are as guilty as those who commit actual racial violence. Actual racial violence. If you don't say anything, it's the equivalent of actual racial violence. More systemic racism. We have diversion, inclusion, and equity doctrines. We have that going on. Let's see what else. While technically rooted in CRT, the D.I.E. industry, what is that? The diversity, inclusion, and equity is D.I.E. Let's read this one. After accusing class members of engaging in violence, if they do not ascribe to California's racially diverse ideas. Defendants' communications propose to implement a plan of atonement, putting in place training and hiring practices that implement CRT-approved loyalty oaths and racial quotas. In CRT, this is what is referred to as D.I.E, diversity, inclusion, and equity. You think they could have come up with a better acronym than that? Hey, we're going to teach you about CRT. Oh, what are you going to teach me? Well, we're going to give you the acronym. D.I.E. Huh? Like the country. All right. So they say, as explained above, while the terms carry a certain meaning to the average person, they mean something entirely different in CRT terminology. The word equity in D.I.E initiatives does not mean equality of opportunity for all, regardless of immutable characteristics. Instead, it means specifically the use of racial quotas to achieve representation of racial groups in proportion to their overall percentages in a given population. Talking about equity and inclusion questions in interviews. Defendants justify the implementation of their unlawful race-based policies by following a dialectical structure that mirrors CRT's indoctrination methodology. And we talked about this yesterday. Remember where I was saying that this is such a beautiful concept, a theory, because anything that you say to combat it, you're a racist. It's like judo. Use your opponent's energy against them. Topsy-turvy, the whole situation. Now, if you say, hey, your CRT theory is stupid and this is asinine, doesn't make any sense, you know what they say? Oh, you're a racist with white privilege. Yeah, of course you don't know and understand this because you are basically contributing to the patriarchal hegemony that exists in society. So I hope you sleep well tonight. Robert. All right. Says first, how does this work? How do they indoctrinate you with CRT? First, defendants bring up examples of isolated incidents that they claim without evidence are rooted in racism. Can you think of any of those? Basically everything. Isolated incidents they claim without evidence are rooted in racism. Literally everything. Everything. Somebody holds up their hand on Jeopardy, racist. Whole country needs to stop and pause as all the media starts to hyperventilate over that. Clearly racist. Second, defendants use those incidents as proof of their conclusory allegation that any racially disparate outcomes in society are product of racism, even when the claims are belied by empirical evidence. Everything is racism. Third, they propose to, quote, dialogue about the issues while making it clear that any opinions opposing the narrative will be met with retaliation. Fourth, defendants propose to implement D.I.E in their agencies through the means of race-based hiring, promotion, and other terms and conditions of employment. We're very familiar with this stuff. This is going on in California now. Take a quick look at what's going on. June 4th, 2020, defendant published an email, so this is California, to all employees, insinuating that white employees should recognize their, quote, white privilege. So this is somebody from the government sending an email talking about white privilege and demanding that employees view every incident between people of different races as evidence of targeted acts of systemically racist violence and oppression. Imagine getting an email like that from your boss. You're just a white guy working. Hey, I'm just, typing some emails. Hey, having a good day. Oh, well, my boss sent an email. I wonder what defendant Bonham has to say. Oh, open it up. Email says, hey, Robert, you white racist. Anytime you get into a little conversation with anybody here at the office, you piece of garbage, I want you to think about how you're contributing to targeted acts of systemically racist violence and oppression because of your white privilege. I'm just answering emails here. I don't know what you're talking about. White privilege, there it is. Bonham states that his decision to publish the email arose directly from a CRT-inspired thought process, an article to white organizational leaders that said silence is violence. Stupid catchphrases. The email itself strictly follows CRT programming, perpetuating the violence of the system, blah, blah, blah. Bonham's invitation to build a culture of dialogue. Yeah, right. Meaning what? Read in light of the tone messaging of the rest of the email, which demands that employees recognize their privilege and accept CRT's politically biased vision of America as a hopelessly racist nation, make it clear that the only dialogue that is acceptable is the one that includes CRT-approved talking points that are openly hostile to white employees strictly due to their race. That is the definition of inclusion in CRT's D.I.E programming. Folks, if you haven't donated to this legal cause, this is probably a good time to do that. Let's see what else we have going on. They have a nice little summation here. First, the speakers engage in selection bias of isolated incidents as proof of systemic racism. So what are these isolated incidents? Defendants, Crowfoot, let's say, America has a mental illness. White supremacy is a mental illness. It manifests itself in so many ways. We are all susceptible to it. You have to recognize that even if you're a liberal, even if you support progressive causes, that doesn't mean you don't harbor racist views because of the society we've grown up in. The default of white supremacy exists in America. Who's saying this? Crowfoot? Participate in Crowfoot's Secretary Speakers Series. So Crowfoot, oh my God, too many people to keep track of here. Let's see what else we have. All right, we got some questions coming in over from watchingthewatchers.locals.com. Let's see who's up first. 2A all day, every day says, all it means is it's about indoctrination. Yeah, very clearly, right? And it's bizarre indoctrination. And it'd be hard to be an employee, honestly, at one of these places and just sit there and be told all day, you're a racist, you're a racist, you're a racist. Everything you do is racist. And if you don't agree, you're even a double racist and a triple racist. And if you don't speak up, you're a quadruple racist. It'd be like, all right, I'm out of here. Speech Unleashed says, can the U.S. Supreme Court rule these type of state policies as unconstitutional across the board? Yeah, they certainly could. They could say that this violates equal protection under the 14th Amendment easily, right? Or a number of other different provisions that I think are probably found elsewhere in the laws, in employment law and other civil rights statutes, but certainly, right? Equal protection. One particular group is being villainized and demonized relative to another group. That's not equal protection under the law, not in any way. 2A all day, every day says, isn't this just a rewording of the affirmative action that was shit canned years ago? Yeah, it is. Essentially, it is. But this is a little bit more, I would say, aggressive, right? Affirmative action was sort of about, fairness. Well, we're just trying to even things out a little bit. We want to give some other people some cultural boosts a little bit. We'll just sort of, even the ability for equal opportunity. This is not what we're talking about now. We're talking about the equity of the outcome. Now we're talking about demonizing and actually, in my opinion, being actively racist against certain races in this country, like explicitly in writing. But what do I know? I'm a white person. I don't know anything about race. I'm just ignorant to this whole thing. I have no opinions. Nothing I say is valid because of the color of my skin. Other people have judged that to be the case. And as we all know about judging people on the basis of their skin color, perfectly acceptable thing to do these days, because obviously the CRT theorists are doing it every day, as we see in this court paper. Sharon Quidney says, in spite of empirical evidence, don't you just love these folks? It's all about the science, folks, dismissing empirical evidence, which is essential to scientific inquiry. There's not too much about that in this concept. This is about, I think, serious levels of indoctrination to the point where people increase the division in this country such that it prompts strong calls for action that is in alignment with their stated end desires. Anki Wo says, if race-baiting hiring is good enough for Biden, must be good enough for California. He announced he would select a woman of color for VP because gender and color shopping is somehow acceptable in practice now. Yeah, I mean, it literally is like that, right? We saw yesterday the CIA had the Latina woman saying, I don't check boxes. My life is more than just a box checking exercise, is I think her exact quote. And she then spends 2 minutes and 18 seconds checking all of the boxes. I'm a cisgender, a millennial. I've got generalized anxiety disorder. I got kids. I can speak Spanish. I can speak English. That's where this is going now. You just have to sort of have the right racial makeup and gender parts, but I don't know that matters though anymore, because you can kind of just change them at every turn. Last question on this segment comes over from HLB, says, this is not giving up vibes of how they want to convict people of stuff based on their social media history when that goes public. Just kidding. That would get politicians messed up. Just kidding. They would hide it. And this sort of stuff never applies to the powerful. Well, we talked a little bit about this CRT stuff yesterday, HLB. And I think that there was a good sort of a synopsis of what this means and to whom. In particular, what is the critical race theory? What does that do for people? What does it do for the people in power? What does it do for the billionaires and the top 1%, for the CEOs, for the CIA, for the FBI, for any of our government people? What does it give them? Well, it gives them a lot of talking points, right? They can get behind this one way or the other, and they can rant and rave about it all day. Meanwhile, all of the little people, the people like me who are, on YouTube and elsewhere arguing about these things, we're all just sort of wasting our time talking about locker rooms and gender pronouns and, who can do whatever with whom and whatever bedroom, which way from Sunday. No, I just don't particularly care about. But it is making sure that we're all not focused on some of the more important things, like, $4 trillion in new spending. How about that? How about inflation that Warren Buffett and many others, including the Federal Reserve, say, well, it might hit us like a sack of bricks come September and beyond in Q4. So, there's a lot of other things that we could be focused on. We could actually talk about justice reform, like meaningful justice reform. Or we could talk about, racial inequity, white privilege, systemic racism, and all of this crap that is meant to be divisive, not meant to be solution-oriented, which is what makes it so frustrating. All right, so thank you for those questions. Once again, came over from watchingthewatchers.locals.com.